Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of the law firm of Hull & Hull, a firm which specializes in estate, trust, and capacity litigation. I am very pleased to be joined today by our co-founding partner, Ian Hull, and by counsel to our firm and professor at Queen's University, David Freedman. Thank you for joining me, gentlemen. Today I thought we would talk a little bit about some of the interesting aspects of estate law. And one of the things that I enjoy the most is the fact that there are so many facets of law that actually intersect with our area of estates, like the real estate area and the corporate law area. Ian, starting with you, we hear about these concepts of joint tenancy and tenancy in common when people own property. What exactly is the difference between the two?
Well, I think because we have the professor here, I'm going to defer to his definitional approach to it. But joint tenancy is the one that we're all most familiar with, and that is a husband and wife. They buy a house together, and it's jointly owned. And on the death of either of them, the asset passes automatically to the survivor. And that's the classic real estate transaction that many of us see.
Yeah, it's an interesting concept. It goes right back to the Middle Ages, actually. And today still remains a very effective planning tool in planning an estate to allow from property to go from a husband to a wife, a cohabitational partner to another partner, a parent to a child, and can be very efficient in terms of tax, but it has to be done right.
And tenancy in common, David, what is that and how is it different?
Tenancy in common means that the people that are joint on the title each have their own share. And that share of that property can be sold by them, it can be mortgaged by them, it can be taken by a creditor, it can be given to somebody in their will. They own that. With a joint tenancy, the people that are on title, they own everything together, and the title gets reassigned as the joint tenants die until there's only one tenant left, and then they take the property together. So it's said that they own everything together, but know nothing individually. And tenancy in common is the opposite.
And the interesting thing with, on an intake level, when we take in when we're sitting across the table taking will instructions, many of my clients will say, well, it's in joint. I think it's in joint. And I'll often press back and say, look, do you mind if I just do the search on title just to make sure that that's in fact the case, because we don't want any confusion, because of course the estate planning effect of it is dramatically different. And so I will insist in lots of cases, just saying, look, I'm going to do another search just to make sure that's the case.
That's great advice, Ian.
The other part of that too is, of course, with joint tenancy, it can be severed without notice to the other tenant. So two partners are living in common law. One gets really grumpy with the other, walks into a lawyer's office, and files the right documents on title, can sever the joint tenancy without notice to the other partner. So that has created a crystallized right for that one individual who's decided, you know what, I'm not going to trust this. I don't want to stand on the top of the stairs with my partner who might push me down them and take the house.
It can be done by conduct as well, which is a lot harder.
Yes.
But I think you're absolutely right. When dealing with these joint tenancy cases, it's really necessary to be careful to make sure that that title is in fact what you want it to be.
Very good advice. Now, when it comes to actually doing something after death in terms of getting the title properly set up for the individual who's surviving or who's entitled to the property, what is the process that one follows, Ian?
Well, I personally don't practice real estate, so I don't actually do the mechanics of it, but it is a very simple mechanical step that if you're in joint tenancy, you just file a survivorship application on title. So it's notice to the world that effectively the passing of the one individual crystallizes the 100% interest of the property in the remaining joint tenant. Now, it may be that there are more than one joint tenants, and that would, of course, wouldn't give it 100% to the remaining one. But it's an important step, and one that I'll often just deal with right away in an estate administration. Get that part of it done so that it's notice to the world. The joint tenancy's over. The surviving spouse has got full ownership of the property.
And David, we see many estate planning techniques, and many times people will have a company or two as part of their estate plan. Can an estate actually own a corporation?
Well, estates, sure, can own corporations, and it really depends on what kinds of powers are given to the estate trustee in a will. And it often makes sense for an estate to own a corporation. Let's say the corporation is actually a working business. and the person that started the business and really was the driving force passes away, the value of that business is at its maximum while it's still working and it's still together. If you try to sell it to be able to give the parts to individual beneficiaries, the asset value is much, much less. So it may be that it's preferable to leave an estate open for an amount of time while the business continues to work, and perhaps one of the beneficiaries will purchase it, or perhaps it'll be spun out into a trust or something like that, whatever suits the parties. And things can get complex because it's both a corporate law applies as well as the law of wills and estates applies.
And Ian, how long can an estate be open?
Well, it's a good question, and there are certain ultimate restrictions which, depending on how the trust arrangements are established, will limit the lifetime of an estate. But you're looking typically at, in a non-trust arrangement, typically most estates are designed to be wound up, not necessarily within the first year, they call it the executor's year, and that is often the D-Day for a relatively straightforward estate administration. But sometimes with ongoing corporations and so on, as David's referring to, an estate might have to run its course. You don't want to have a fire sale. The estate trustee is in charge of managing this asset and wants to put it in the right market. You want to grab the spring market for the house, and so on. So it really depends on the nature of the assets, and then there's some very archaic laws that talk about perpetuities and things like that that we don't need to worry about because it rarely arises.
So clearly, it really does underscore the importance of proper estate planning, given that people can have these varied assets. Well, thank you very much. And thank you for joining us here at Hull & Hull TV.